The following court documents deal with the inability of the King County Superior Courthouse to act appropriately concerning a person who is dealing with symptomatic mental disorders. The story begins on June 11, 1999, when my then wife filed a no-contact order listing 15 false allegations against me in her quest to not have to undergo her previously agreed upon psychiatric appointment to help her deal with her addiction to credit cards and her constant suffering from severe bouts of depression and obsessive compulsive behaviors. The 15 original allegations included that I was alleged to have been domestically violent by ex-wife, that I was allegedly emotionally abusive with our stepdaughter, I allegedly held my stepdaughter by her neck against a wall and caused bruises, reported that I allegedly screamed at our daughter at church and was asked not to return during her confirmation ceremony, that I allegedly attacked my father-in-law, tackled him to the floor, and wrestled a banner from his arms in front of our entire congregation at our church during my daughter's confirmation ceremony on 3/28/99. I'm responsible for family's current predicament, that I was allegedly verbally abusive towards my wife's parents, that I allegedly some 5 years previous to the filing of this document I had sexually molested our daughter when she was 8 years old. I was responsible for our daughter's alleged suicide attempts in 1999. I pounded on our daughter's door so hard that I broke it in a fit of rage and refused to replace it for 21 days. I had allegedly hit my eldest son in the face at church. I allegedly had our family locked in our home with a key deadbolt lock. I had put locks on the sliding glass doors and bottom windows, and that I was the only one with the keys in order to keep control of our family. That I had allegedly punched the wall after a confrontation with my stepdaughter and put my hands on her neck. That I had allegedly stalked my stepdaughter at school and went through her locker in 1993. And in September of 1998, that I had allegedly slapped our daughter's hand and cheek and yelled at her friends. Added to this, my then mother-in-law filed a similar no-contact order along with a police report on the same day in an adjacent county, filing similar false allegations along with a false allegation of my breaking into her house, accompanied by my then 3- and 5-year-old sons. The additional charges being entering her house through her garage, finding a fishing knife that belonged to her husband, and left it on the floor in their den, where such an act was clearly designed to try and intimidate them. That I used a key I allegedly obtained from the trunk of my then wife's car to gain access to her family home. That her bed was disheveled, swivel chairs had been moved, stating that this was caused by my sons. The June 8, 1999 police report filed by ex-mother-in-law, in which she states, she went inside and checked around to see if anyone was home, but found no one and nothing was missing or disturbed. We looked around the house but did not find anything else out of the ordinary. There was no signs of forced entry and the front door was still locked when they returned home. If an entry was made, it was through the garage and back out the same way. During my conversation with her, she told me that her husband has a problem with memory loss. While there, he forgot twice that he gave me the knife and was not sure where it was found. I asked her in private if husband might have armed himself with the knife when they were searching the home and forgot he left it upstairs, and she said she did not believe so. Because of my mother-in-law's contradictory testimony and proven false statements, her case was dropped on August 5, 1999, and I, along with my 3- and 5-year-old sons, were exonerated, at least in this case. Equally confusing, as well as distressing, were the following 2 commemorative cards given to me by my then wife celebrating our anniversary on June 17, 1999, and Father's Day on June 21, 1999, both being sent well after her June 11, 1999 No contact order was filed. Following are portions of many of the letters, videos of evidence used to disprove a good number of the 15 original allegations as filed against me by my ex-wife and mother-in-law. Dr. Hedrick's July 31, 2000 GAL report speaks to allegations 1, 2, 4, 6, 7, and 8 by stating, although ex-wife denied ever having any difficulties with her mother intruding in our family, there is considerable evidence in the record that this has been a significant and ongoing problem. She appears to have wrestled with the issue briefly, tried to set some limits with her mother, and then capitulated. My ex-wife made wide-ranging accusations against me that I may have sexually abused my daughter, that my parents were alcoholic, that I violated the court order and was sitting on their lawn, that I did not have my teaching contract renewed because I threw an overhead projector on one occasion and an eraser on another, that I was threatening in front of the boys to burn the house down, that I broke into her parents' house and left a fishing knife on the floor, that I had repeatedly tampered with her car, tapped her phone, made obscene phone calls, that I had gone to the leadership of their church and told them she was not qualified for her position as musical director. However, when pressed to corroborate these allegations, she was not able to supply any credible evidence. For instance, when asked about her statement that my parents were alcoholic, she stated, "Oh, I read that in a report somewhere." This statement appears in a report regarding stepdaughter and is a statement she made during a time when she was acting out significantly and was having obvious problems with reliability. When asked if she had any first-hand knowledge of her in-laws having substance abuse problems, she acknowledged that, personally, I never saw any evidence. This pattern suggests problems with judgment and credibility. Moreover, when asked about the issue of credit card debt, she at first denied that all 3 house refinancings had been to pay off credit cards. However, when it became clear that there was paperwork which suggested otherwise, she acknowledged the fact. My ex-wife appears to manipulate information freely with the hope that no one will look very closely. Ex-wife is a largely ineffectual parent. May 5, 1992, Geraldine Sue, Social Worker 3 letter. This letter speaks to allegations 2, 3, and 4 by stating that I had intervened in a fight between my wife and stepdaughter to keep them from hurting each other, that I grabbed stepdaughter around the neck from behind in order to pull her off of her mother in an effort to break up this fight and to keep her from leaving the home. There was no indication that I intended to choke her. April 14, 1992, Hamilton CPS report speaks to allegations 2, 3, and 13 by stating, stepdaughter appears to be caught in a web of family dysfunctional interaction patterns in which an extended family member, maternal grandmother, often fuels. Stepdaughter and her mother lived with maternal grandmother between marriages, and she took over the parenting role. She had not until recently understood the importance of giving up that role, plus her alliance with stepdaughter against me. I have also been caught in the web fighting to keep my family intact against my mother-in-law's wishes and to maintain a role of authority with paternal grandmother. February 18, 1992, CPS report. This report covers allegations 1, 2, 3, 4, 9, and 13 by stating, stepdaughter and her mother were arguing. The stepfather intervened in order to try and keep her from leaving to go and spend the night with her boyfriend. He grabbed her around the neck from behind. There is no indication he intended to choke her, and no bruises were left. Again, this was done to try and restrain her from leaving the home. As stated by stepdaughter, the stepfather was raised in a home that was very strict. He was raised in an alcoholic home. This was later proven to be purposeful misinformation perpetrated by stepdaughter when she was out of control. Wife's parents reside in Bellingham. They have threatened to get an attorney and seek custody of stepdaughter. Referent has the impression that stepdaughter has manipulated the extended family into being against me. April 4th, 1992. Previous police report filed by ex-mother-in-law against me in which she alleges I attacked my stepdaughter and tried to choke her. This report covers allegations 2 and 3 by stating, phone call to referent Vidheim. He indicated that he is in counseling with the family and saw them 2 or 3 hours after this altercation. He did not see any bruises on stepdaughter at that time. He stated that stepdaughter refuses to participate in counseling and is out of control. May 4th, 1998. Jean Marie Lucci, MD, letter which speaks to allegation 12 by stating, parents report that he, eldest son, has had outbursts such as throwing his little brother against the fireplace, scratching his brother's face, and running out of the house so that the parents have put locks on the windows and a key to a dead bolt on the front door. Not for me to lock the family in the house as alleged by ex-wife. August 12, 1999. Dr. Joslin letter, our daughter's pediatrician, which speaks to allegation 8 concerning my having allegedly molested my daughter by stating, review of her medical records does not provide any evidence for sexual molestation either by history or physical exam. July 16, 1999. Pastor Reese letter which speaks to allegations 4 and 5, confirmation ceremony. On that date, I did not personally witness any angry or agitated conversation between father and his daughter. Second, it is also untrue that I exchanged words with father on that day to the effect that he should never again come back to our congregation. September 19, 1999. Sitzman letter which speaks to allegations 4 and 5 by stating, at no time during this rehearsal process, daughter's confirmation ceremony, did I witness anything that could be construed as a struggle, confrontation, or disruptive behavior by father. If such behavior had occurred, I'm convinced it would have been extremely obvious to anyone there and I would have noticed it. December 4th, 1999. James letter concerning allegations 4 and 5 by stating, I did not see or hear any outbursts or disturbance at daughter's confirmation ceremony at church involving father on that date, nor did I hear of any such disturbance afterwards. As you will note throughout this entire film, not once did I attack, tackle, or grab a banner for my then father-in-law as alleged by my ex-wife and ex-mother-in-law. Please note, it was on June 11th, 1999, less than 3 months after this film was made, that my ex-wife left me, and she, along with my ex-mother-in-law, filed their duplicitous no-contact orders. February 17th, 2000. Letter written by Dr. Wang, our daughter's psychiatrist, which speaks to my daughter's alleged suicide attempt, in which he contradicts my ex-wife blaming me for it and her falsely alleging that he recommended that my daughter move out of our house and in with my ex-wife's sister and brother-in-law. To the best of my recollection, as well as review of chart information, there was no documentation of any wound or scar to her wrist at the time of hospitalization. The hospital also did not feel compelled to give a recommendation as to where Mika should live, since we did not have any reasons to suggest one plan over another. Similarly, as with my daughter's alleged first attempt at suicide on November 7, 1998, my ex-wife told me that our daughter had taken 100 Advil tablets. When I took her to the hospital to have her tested for drugs, the doctors concluded that there were no drugs in my daughter's system, let alone Tylenol. June 21st, 1999. Dr. Wang's hospital report, in which it is reiterated that my daughter never tried to cut her wrists in an alleged attempt to commit suicide. He reports, recently locked in bathroom with a razor blade, but did not cut self. Patient labile at menstrual cycle. That's when she gets suicidal. Not due to alleged conflicts at home, as stated by ex-wife in her no-contact order. This report also goes on to state they, mother and daughter, deny that he, father, has been physically abusive towards anyone. For ex-wife's evidence against me, she uses 2 assessments as a means of backing up her claims. The first report, actually a letter, was written on June 24, 1999 by Myrna Pinedo, Ph.D., who at this time was a licensed marriage counselor. Please note, at this time Myrna Pinedo was not a licensed psychologist, psychiatrist, or a licensed domestic violence counselor, but a certified counselor, having obtained her Ph.D. in philosophy. The entirety of Dr. Pinedo's summary is based on information provided to her by my ex-wife, her mother, and my ex-wife's sister and her husband. At no time during this time period did Dr. Pinedo make any effort to contact me, my family members, or my witnesses to discuss these allegations. The other document was an assessment submitted by Douglas Bartholomew, M.S., on August 13, 1999, which was his domestic violence assessment of me as requested by Myrna Pinedo, Ph.D. The Douglas Bartholomew report, as presented, was based primarily on the 15 false allegations submitted by my ex-wife, along with the Myrna Pinedo, Ph.D. letter, to which he concluded that I present with many, if not most, of the traits commonly associated with the offender population. The result of these 2 documents being I had to attend and complete a DV class. I was only allowed to have supervised visitations with my 2 sons until I completed this DV course. I was not allowed to see my daughter. This court order remained in effect for several months until Dr. Hedrick's July 31, 2000 GAL report was finally submitted, which proved beyond a reasonable doubt that my ex-wife had indeed submitted false testimony against me. Myrna Pinedo, Ph.D., as well as Doug Bartholomew, M.S., were never reprimanded by the court for submitting false evidentiary documents. Their documents were just declared as being inconsequential and were not used for the final consideration in the drafting of our final parenting plan. This past year, though, on February 22, 2013, case number M2011-1 2023 due to the continual and ongoing complaints filed against Doug Bartholomew, MS, to the Washington State Department of Health. It was officially declared that his assessments were consistently unprofessional, biased, incompetent, neglectful, and extremely poorly written. The result being that he was banned for 2 years from being allowed to write any more DV assessments, and he was fined $65,000. He has recently filed for bankruptcy. Additional information concerning this matter can be found at the Washington State Department of Health, www.doh.wa.gov/, or Superior Court Judges Association, superiorcourtjudgesassociation.com/. The greatest tragedy in this entire situation still remains to be the lost relationship between my daughter and myself. To date, it has been over 14 years since I last saw her. It should be noted, as stated in the July 21, 2000 GAL report, my daughter's statements about me were riddled with evidence of having uncritically accepted much of her mother's statements and agendas. Some of what this can be attributed to is, on October 4, 1998, my daughter, 13 years old at this time, and my then wife sneaking a young man into her bedroom by the name of Andy Phillips around 10 p.m., well after my sons and I are in bed and asleep. When I am suddenly awoken by voices coming from my daughter's room, I rush in, causing damage to her bedroom door. It was blocked by her dresser, and catch them in the act of having sex. This explains allegation number 10 of pounding on my daughter's door so hard that I broke it in a fit of rage. As can be noted from the August 5, 1998 police report that I filed against Andy Phillips for breaking and entering along with assault, the only thing he left the house with was his black boxer shorts and his pants. The rest of his clothes I turned in as evidence against him. On December 28, 1998, without my knowledge, my wife conspired with her mother and her sister to send our daughter to see our then runaway stepdaughter, who at this time was living as a known strip dancer, stage name China Doll, at an all-male review club in Memphis, Tennessee, and who had a known history of drug abuse. When our daughter returned home, our once loving relationship was never the same. August 22, 1999, divorce hearing. My ex-wife had her sister bring our daughter to this hearing. She wasn't noticed until after the hearing was over, thus allowing her to listen to all of the false allegations being leveled against me. And even though the court commissioner reprimanded my ex-wife for having done this, there is no doubt in the subsequent damage this had in our relationship. Within a year after my ex-wife left me, and I having been forced to move out of our house, she allowed our daughter, who was 15 years old at this time, to have a young man by the name of Jason Craig move into the house and into our daughter's bedroom. Even though our sons and I reported this to CPS, the police, to several of our friends, and even my ex-wife's pastor, nothing was ever done about it. As I was later told by my sons, Jason was only the first of several young men allowed by my ex-wife to come and live with our daughter during her high school years in my ex-wife's house. These incidences only cover a few of the undermining events that helped to circumvent the once loving relationship between my daughter and myself. Moreover, because of the inept handling of this situation by the King County Superior Court, my ex-wife still refuses to seek help for her ongoing bouts of depression, her helplessness in trying to gain support to overcome her credit card addictions, and her ongoing obsessive-compulsive behaviors. Her continual behavioral concerns can be witnessed in the following pictures taken by my oldest son in and about her house. A garage that was so clean you could park both family cars in it, walk freely about, and actually work in. Is now so full of stuff you can't even enter it, let alone walk around, park the cars, or do any projects. A basement where our daughter once had the space to model her Halloween costume. Has now become a dumping ground filled with packed boxes and loose paper. A laundry room with no place to work, let alone do one's laundry without tripping over excessive amounts of clothes and boxes. A kitchen once so well kept that it was a joy to host family gatherings in. Is now so unkept you can't even sit at or even eat off of the kitchen table anymore. A backyard where our daughter once loved to play. Now is so overgrown it is hard to think that anything fun ever happened here. The once lush and green upper section of our backyard where our daughter took some of her very first baby steps. Has now been taken over by fallen branches, weeds, blackberry bushes, and ivy. A once well-groomed yard where family members would gather and our daughter would play on her swing set. Has taken on the appearance of an abandoned yard and home due to the lack of maintenance and overgrowth. The rest of the house is in equal disarray, with no hope of ever looking as it once had. With no hope of my ex-wife ever seeking psychiatric help to confront her disconcerting conduct. And what is truly tragic, on June 27, 2013, my mother, our daughter's paternal grandmother, passed away. She left this world not having seen her granddaughter for over 14 years, not being able to hold her one last time, not being able to say how much she loved her, not even being able to say goodbye. Though this only reveals a small portion of what I have been subjected to over the past 14 years because of the King County Superior Court, I still hold out the hope that one day my daughter and I will once again share a joyous moment together as we once did. For as it is written in Psalms 23, verses 1 to 6, I truly believe in the following prayer. Thank you, and God bless.